So today we're going to be talking about estate planning. We're looking at some special considerations for minor children and also for disabled children. I am Jennifer Williams. I'm with the University of Missouri Extension out of Carter County. Prior to coming on board with Extension, I was a practicing attorney for 8 years. During that time, I did quite a bit of estate planning for families. And before I became an attorney, I actually worked for the probate court for 4 years. So I was part of the court team that processed guardianships and decedents' estates and all of those things that are not really super fun to talk about, but are unfortunately sometimes very necessary. As always, this is kind of our warning. The information that we're giving you today is not legal advice. I'm not here in my capacity as an attorney. I'm really here to just provide you some general information today that will hopefully steer you in the direction of knowing, hey, this is what I need to talk to an attorney about. So to get some information about your specific case, make sure that you consult with an attorney that you've chosen so that they can give you really an in-depth perspective of what you might need. Now, like I said, today we're talking about this estate planning. It's something that nobody really likes to have to talk about, but it is so, so important. And so we're going to do something a little bit different today than the presentations we've done in the past. We're actually going to take a look at a family. Now, it's a fictional family, of course, but this is sort of a conglomeration of things that I have seen along the way in my practice. And so you may see a little bit of your own family here, your own financial circumstances, your own situation here, and that's okay. But what we're going to do is we're going to look at our family, and this family has done absolutely no planning for the future. And we're going to see where life takes them and what that lack of planning results in for them. And then we're going to take a minute and we're going to shift and look at the tools inside an estate planner's toolbox and see what tools there are. Then we're going to take those tools and apply that to our family and see what sort of difference it might have made for them. Okay? So we're going to do that right now by meeting our family. So we have Charlie and Cindy, and don't they make a sweet looking little couple, y'all? Charlie and Cindy have been married for 11 years, and they are, Charlie has an adopted son from his previous relationship, and his son's name is Chester, and he's 15, so he is still a minor. Cindy also has a son from her previous relationship, and his name is Chandler. He's 19, so he's not technically a minor, but he has cerebral palsy. And so he's very high functioning, but even though he's high functioning, it doesn't look likely that he's going to be able to live alone or work alone without some continued assistance. So that's a little bit about who's who in our family. So Charlie and Cindy are doing pretty well for themselves, all things considered. They've got a nice family. They've got some struggles like everybody else. You know what? Are you seeing? I'm not seeing all of my slide here. Oh, okay. Here we go. All right. So I want to take a look at what they've got in their estate. So we've got Charlie's salary. He's a self-employed contractor, makes about $200,000 a year, so he makes some good money. Cindy is an office manager, and she makes about $45,000 a year. So they've got some really substantial income, which is good. They own their home, and it's worth about $300,000. But like a lot of people, they have a mortgage, and so they still owe a lot on their mortgage, and they only have about $5,000 worth of equity in their home. Now, Charlie also drives a 2019 Chevy truck, and so since that's a pretty new truck, he's also got some debt that he owes on that. So that's not a free and clear asset. Nor is Cindy's Cadillac. She's got a pretty new Cadillac that she drives, but it's got a lot of debt left on it as well. They've been able to accumulate some fun things like a boat and a jet ski. And they've been able to put some money back. So Charlie's got a bank account. His checking account has about $2,000. His savings account has about $2,000. Cindy has a checking account, also has some money put back in it. She's also done a little saving. She's invested in a certificate of deposit, and she's got about $100,000 invested in that. But they like to spend money. And so one easy way to do that, unfortunately, is credit cards. And so between the two of them, they have about $55,000 of credit card debt. And then in addition to all of that, they have some extra things. Cindy has a coin collection that she inherited from her family, and she wants to pass that on to her son. Likewise, Charlie's got a gun collection, and he wants to be able to pass that on to his son as well. Those are family collections, and they each intend that those are going to go down to their kiddos. All right. So, like I said, they're doing pretty well for themselves. They're making it. They're getting by. In fact, they're pretty comfortable. But of course, life happens, and it's not always pleasant. Cindy's going down the stairs one day, and she loses her shoe, and she falls, and it causes her to have a traumatic brain injury. And now, all of a sudden, just that quickly, Cindy is no longer able to perform activities of daily living on her own. She can't function. She can't do those things for herself. And so that begs the question then, who's going to be making decisions with regard to Cindy's care? What's going to happen, and who's going to make those choices about her health and her well-being? I think sometimes people assume that it's going to be her spouse just because he is, in fact, her spouse. But the reality is that that is not always the case. Some medical facilities will allow that, and others will not. And so, it could very well be that Charlie finds himself in a situation where he's not able to make decisions about Cindy's health and well-being. I don't know why I've got so many stinking things going on here. We're going to back up one more. All right. So if Charlie happens to run into an organization where they will not allow him to make those decisions as the spouse, his only option at that point is to go to the court and have a court-appointed guardian appointed. And that can cost some money. I mean, it's probably going to be a couple $1,000s if he has to go through that court process. And the court will likely be appointing Charlie to serve as Cindy's guardian since he's her husband. But what if Cindy's family doesn't like him? They've been married 11 years, but what if it's been a little bit tumultuous and Cindy's family says, hey, we don't want you to do that? Now we have a big fight, and the court has to figure out which person should be the guardian. And you know what that does to your legal bills. Now, all of a sudden, those legal bills are completely through the roof. Now, we also need to figure out who's going to take care of Chandler, because remember, she has this son and he has some special needs. So what's going to end up happening to him? Well, remember, he is not a minor child. He's 19 years old. And so because he's 19, he's technically considered to be an adult. And so because of that, I think that the law presumes that he's going to take care of himself, at least initially. And that may work for a while. I mean, remember, he is pretty high functioning. He doesn't have maybe as severe limitations as other folks might. But then again, that may not work very well long term. I mean, let's face it, 19-year-olds don't always make the most wise decisions, even under the best of circumstances. And so having his age coupled with a disability, that could result in disaster, right? All right. So if he's not going to be taking care of himself, that means there's going to have to be a court-appointed guardian for Chandler. And so it can't be Cindy. She's not able to make her own decisions at this point. And so it might be Charlie. Now, the result of this is, no matter who it is, this is now court case number 2. We have our guardianship for Cindy, and we also have our guardianship now for Chandler. And so, we've paid for a court case for Cindy. Now we're having to pay for a court case for Chandler, and hopefully nobody's fighting about who needs to be Chandler's guardian, right? We also need to figure out, though, who's going to make decisions about Cindy's stuff. Okay, remember, she's got those bank accounts, she has her vehicle, she has that certificate of deposit. Somebody's got to be managing that stuff in her absence or in her inability to do so. And so when Charlie's going to the court and asking for authority about, hey, I need to make decisions about her person, he probably better be asking for authority to make decisions about her stuff as well. And so the court can appoint him both as the guardian of her person and as the conservator of her estate. And that's probably a good idea under the circumstances. All right. Now, we have Cindy's traumatic brain injury. That's come on pretty quickly, right? But we've just had Cindy's loss of income, right? She's not making that $45,000 a year. I think I skipped a slide too far. Let me back up one. Yeah. What if Cindy needs nursing home care? Remember, she's got this traumatic brain injury. She's not able to take care of her day-to-day functions on her own. If she needs more care than Charlie can provide at home, who's going to pay for that? And so, even though Charlie and Cindy do pretty well for themselves, she's lost that income. She's no longer making that $45,000 a year. They don't have any equity really in their home. They owe on all their vehicles. They have that credit card debt. They are the poster family for what I call being in the donut hole. They have too much stuff to qualify for Medicaid, but not enough to actually be able to pay the money it's going to cost each month to keep Cindy in a nursing home. Nursing home care is about $5,000 a month on average right now, and in some places it's even more than that. So, they're really in the gap, so to speak. And so ordinarily, Medicaid's going to require them to deplete all of their assets in order to qualify and then kick in and start paying for her nursing home care. So that's a pretty bad result. I did want to look at the chat. April had a question. Jennifer, can you please tell us what the average cost would be to become a court-appointed guardian for most counties in Missouri? The filing fee is anywhere usually between $100 to $200. There is a cost usually for a guardian ad litem to represent the incapacitated person. That can be a couple $100. And then your attorney's fees for the attorney to actually file it can be anywhere from $1,000 on up. It depends on how complicated, how contentious it gets. If more than one person's coming in fighting, it's going to get expensive very quickly. Legal aid does from time to time pay funds for guardianships, but it's not very common. And so that's not something that I would count on. I've seen it a handful of times, but I wouldn't count on it very frequently. Okay, so now we've got a situation where Cindy's had to be in the nursing home. We've had to expend all of our estate assets to try to pay for that, or pay for it out of pocket on our own. So we've got Cindy's traumatic brain injury, but the hits just keep on coming. Charlie now has an accident at the construction site and a steel beam falls on him and he passes away. And so now Cindy's in the nursing home and poor Charlie, he is deceased. So now we have to figure out what happens to Charlie's stuff. Now remember, he's got a vehicle, some bank accounts, he's got that gun collection that he wanted passed down to his child. So who gets his stuff? Well, guess what? Back to court we go. We're now at case number 3. It's pretty crazy that we're having to go to yet a third court situation in order for the court to tell us how his stuff gets divided. All right, so the way that this works here in Missouri is Missouri has a law that says, hey, if you don't have a plan for who gets your stuff, here's how it's going to get divvied up. And that plan is called intestate succession. And so in this particular situation, Cindy would get 1/2 of Charlie's stuff and his son Chester would get the other 1/2. Do you think that's really what Charlie wanted? Do you think that he wanted Cindy to get half of that gun collection, for example? Well, we know that's not true. We know that wasn't his intention with the gun collection, at least. But that's what the law is going to do because there was no direction to the contrary. But let's also think back to Cindy for just a minute. Remember, she got Medicaid to pay for her nursing home by spending down assets, and now she's getting a new inheritance. What do you think that does for her? It's going to disrupt her Medicaid service, and then she's going to have to spend down this new amount of money in order to get back to the point where Medicaid will continue to pay for her nursing home care. So it just creates a whole lot of problems there. All right, the other issue we have is who's going to take care of 15-year-old Chester, right? He's not able to take care of himself, so we have to figure out who's going to. Well, Cindy's not able to because she's got her own guardian. 19-year-old stepbrother can't because of his disability. Charlie's deceased. Let's hope that Charlie's got some family who can take care of this kid, right? But what if that family doesn't live close? Now we have a situation where they have to go back to court. Now we're at court case number 4, right? They get some family member hopefully will get guardianship of Chester, but this may mean that Chester has to move out of his house. It may mean that he has to change schools. It may mean that he has to move completely out of state. So this is really, really not an ideal situation either. That also brings us back to who's going to be making decisions about Cindy now. Because remember, we had Charlie as her legal guardian. And so he was the one making those decisions. And now that he's deceased, now what happens? Well, back to court we go. Hopefully, her family will be able to step in. But the reality is we've got to have somebody who is a different court-appointed guardian. And so it may be, if she doesn't have family who can step in, she may end up being a client of our local public administrator. That's an elected official, elected by the voters, but they are a stranger, and their entire job is to step in and manage estates for people who don't have family that is willing or able to do it. And so poor Cindy may end up with a complete stranger making decisions about her well-being. That also brings us back to Chandler, her son. We're going to have that exact same problem with Chandler. And so it actually may end up being that the public administrator ends up with 2 new clients instead of just 1 as a result of this. So this is a really, really rough situation. But it gets worse. So we have Cindy's traumatic brain injury, we have Charlie's death, and now while Cindy's in the nursing home, she gets pneumonia and she passes away. And so this poor family, now we have to figure out how Cindy's assets are going to get distributed. And so we are back to that intestate succession situation where she didn't have any directions. We go back to court. Now I think we're at case number 6. Back to court we go, and the Missouri law is going to tell us how to distribute her stuff. Under Missouri law, the way that that's going to work is 100% of her stuff is going to pass down to her son Chandler. Now, do you think that's really fair? Because think about this for a minute. Cindy inherited 1/2 of Charlie's estate, which means that Charlie's son is only ever going to get 1/2 of his father's estate, whereas Cindy's 1/2 then passes to her son, who isn't even a relative of Charlie's. It's not really a fair outcome, but it is what it is. That's what the law says happens under those circumstances. And so it can really create some unfair situations. We also have to consider what the effect is on Chandler's benefits, because if he's got a disability, he may be receiving some public assistance too. And when he gets this inheritance from his mother, that's probably going to disrupt his public assistance as well. All right, now we can't forget about the nursing home and the Medicaid, right? Because they've paid for Cindy's care along the way, and they want to make sure that they're not left out in the cold. So the first thing that Medicaid's going to do when they start paying is they're going to put a real estate lien on that house. And so even before anything else gets paid, if that house gets sold, Medicaid is the first in line to get proceeds from the sale of that real estate. They're going to make sure that they have a way to get paid back for what they've spent on Cindy's care. And so that may mean that there's nothing left to pass on to heirs under those circumstances. There may also be other claims, other people who are owed money. You remember they have that credit card debt, that $55,000 of credit card debt that may still be sitting around out there. And all of those people can file claims in Cindy's estate and try to get a portion of her estate if there's anything there. So hopefully in the course of all of this, you have figured out what an absolute catastrophe it is if you don't make any kind of plans for the future. The good news is that it doesn't have to be like this. There are lots and lots of tools in an estate planner's toolbox that really could have helped Charlie and Cindy. And so what I'd like to do next is to just take a look at those. Let's see what kind of tools we have, explain a little bit about what they are, and then when we're done with that, we'll apply them to Charlie and Cindy's situation and see how it could have helped. So the first tool we're going to look at is a last will and testament. I often hear people say, well, I have a will, and so that means my stuff doesn't have to go through court, right? Well, unfortunately, that's not true. A will is administered in probate court. A will is simply a document that tells the court, here's how I want my stuff divided. But that document doesn't get any authority until the court says it gets authority. And so you have to go to court in order to have a will that is honored and adhered to. Now, the will directs the distribution of assets. So in other words, the court looks at this will and says, yes, this looks like it was a validly executed will, and it tells us how you wanted your stuff divided, so that's what we're going to do. This is especially useful in situations where you want certain things to go to certain people. Remember, Cindy and Charlie kind of had that gun collection and coin collection that they wanted certain people to have. This is the ideal situation for that. You can say, I want item A to go here. I want to leave so much money over here. It also is really helpful in situations where you don't really want things distributed equally. So you might have a situation where you have 3 children, and during your lifetime, one of those children needed a lot of financial assistance for some reason. And so you gave a lot of money during the course of their lifetime. Then at your death, it's not really fair to divide what's left 3 ways, right? You may not want to do that. So you may want to say, hey, I want the other 2 to have a bigger share to split, and I want to leave less to the third one, or I don't want to leave anything to the third one. And so a will gives you some flexibility to direct how that happens. The other really useful thing about a last will and testament is that it allows you to nominate a guardian for your minor children. And so it gives you the ability to have some input about who you feel is best suited to raise your children if something happens to you. The court still has to abide by the best interest of the child standard. So, if I nominate my sister and she's a drug addict, the court's not going to do that. But it does give you the ability to have some input, and the court does strongly consider that. We're also going to look next at another tool called a power of attorney. This is a document that basically will let you name someone, and that person then essentially gets to stand in your shoes and do the things that you could do for yourself. There are lots of different ways that powers of attorney can be set up. One of them is general, and that means basically that they could do anything that you could do for yourself. The contrast there would be limited. In other words, you may give them the power to only perform one function. This comes up a lot if military personnel, we see this a lot with them, they need to give someone authority to sell a house for them, or sign a lease or something like that. They can do a very narrow power of attorney that's just there to accomplish one specific purpose. They can be springing or they can be immediate. Now, when I say springing, that just means that the power doesn't kick in until a certain condition is met. And usually that condition is incapacity. So in other words, if I give someone a springing power of attorney, they don't actually get to do anything under that document until I am incapacitated. The flip side of that coin then would be that you could give an immediate power of attorney. If I anticipate that I'm going into surgery and I don't have a good outcome, I may want to give someone an immediate power of attorney so that they can immediately start making decisions for me. So that's the difference about when those two different types of conditions could be met. Powers of attorney can be for financial, or they can be for health care, or they can cover both. So powers of attorney give us a lot of flexibility. You want, an opportunity to address both your financial situation as well as your person, your health care, your living arrangements. And finally, you can also include a healthcare directive in your power of attorney. You sometimes hear this referred to as a living will, but basically this is the document that would govern your end of life care. Do I want a ventilator if I'm not going to get any better and it's just going to keep me alive? Do I want CPR? Do I want dialysis? It talks about that and lets you have the ability to have input about those decisions in advance. Next, we're going to talk about non-probate transfers. These are transfers that do not go through the probate court, hence the name non-probate transfers. And one of the most familiar kinds is pay on death or transfer on death designations. And so these you usually see on things like financial accounts. So if you go to your bank and you say, hey, I want to put somebody else's name on my account so that at my death, they get this money, the bank can have you fill out a form and you can nominate your person, and that's that. Then upon your death, the proceeds from that account go to them. Same thing with transfer on death. We usually see that related to vehicles. I can designate my vehicle to transfer on my death to my mother or to my sister or whatever the case may be. So that's a really common one. Other types of beneficiary designations, things like insurance policies, you can designate a beneficiary to receive those proceeds. And if you have designated that person, then it pays directly to them and it does not have to go through the probate court. You can also do this with real estate. So you can do a beneficiary deed, and it is a deed that gets recorded in the land records, and it says, at my death, this is who gets this property. That is changeable. So just because you do it once, if you change your mind, you can do a new deed or you can revoke that deed. So it's not permanent. Anytime prior to your death, you can change it or revoke it. But if you don't, then at your death, whoever you've listed in that deed will receive your property. Finally, you can just make outright gifts. And sometimes that's usually a good way to handle it, especially for things like those coin collections or gun collections. If you have something particular that you want to go to a person, sometimes it's best just to give it to them now. Especially with items of personal property like that, sometimes things have a way of going missing after you pass away and nobody suddenly knows where they are or what happened. So, giving gifts during your lifetime can be a useful tool for non-probate transfers. Another type of thing that we can consider, another tool in our toolbox, is insurance. We need to make sure that we have enough coverage for our life insurance. And so a good way to think about that is called the DIME method. And so each letter of that word stands for a different thing. D stands for debt. You want to make sure that you have enough life insurance coverage to cover any outstanding debts that you have. I is for income replacement. If you have family members who are dependent upon the money that you bring in your salary, you may want to make sure that you have enough to pay a year or maybe even 2 years worth of your income. M, to cover the mortgage. You want to make sure that you're leaving enough to pay off a house so that someone is not having to worry about how to keep that mortgage paid. And finally, E, for education. If you have minor children who need to have college bills paid or something along those lines, you may want to consider that with your life insurance as well. In addition to your DIME method for your life insurance, though, there are other types of insurances that you can buy. Long-term care insurance can be a useful form of insurance, because if you need nursing home care and you may have too much to qualify for Medicaid but not enough to actually pay for it, long-term care insurance can help fill the gap. It's not always a good deal, so you have to talk very carefully with your insurance provider, but definitely could be an option. All right, I want to go back to the chat for a minute because I see that we have had a couple of questions come in. Following up on the question about how much guardianships cost, what can families do if they do not have up to $1,000? We're in the same situation as we were with our custody cases last week. You're just going to have to call around, see if you can find an attorney who will work with you, either do some pro bono or work a payment plan. That's really the only alternative that you have. Mr. Lloyd wanted to know how specific a will has to be. There are specific formation requirements in the statute, and so you can do a will on your own. I don't usually recommend it. I don't recommend people going online and finding forms online or buying, sometimes at Office Depot you see the will kits. I don't usually recommend those because they're not state specific. I do normally recommend that people do that with an attorney because they will know the best ways to make sure that it's compliant with the law. You want it to be specific enough that you want to try to minimize the conflict. So if you want something very specific to go to someone, you need to be pretty specific about that item. But if you want my estate as a whole divided into fourths and given here, 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 you don't have to itemize your estate necessarily. So an attorney will be able to walk you through that. They'll know, hey, we need to be a little more specific about this, maybe not so much about this. And then Barb asked, is the beneficiary deed separate from the property deed? And yes, it is. One client that she had looked into that, was told that the person or beneficiary needed to pass through the title company to be added to the deed. I'm not sure why they would have said that. It is a different deed. So the original property deed is recorded when they purchase the property. Then the second deed, that beneficiary deed, is recorded separately. And typically all that is needed is showing a copy of the death certificate to the assessor's office. And they'll go ahead and retitle that in the land records that way. If you get title insurance on it, I've never heard of a title company asking for any kind of probate case. They normally just want to see a copy of the death certificate. So hopefully that should take care of it. If not, that would be a really rare case. I would have to think there's probably more to the situation than that. Okay.
Jennifer?
So, yes.
I have a question because when we're dealing with kinship, it can even become more complicated. I mean, if you're in an informal situation, the kids may not be in the best situation to go back to their biological parents because that's probably why they're in that situation.
Right.
And, how, and you may not want to leave a lot of stuff to the kids because then you're afraid that parent will come back.
That's right. And we're going to talk about a tool in a little while that may be able to help assist with that. So you're kind of jumping ahead of me, John. Yeah, that just means you're forward thinking. And so that's a good thing. But yeah, we'll talk more about a tool that may be able to help assist with that here in just a quick second. So we're looking at our life insurance. We've looked at our long-term care insurance. Disability insurance is another type of option. So just in case your health gets bad and you're not able to work, you may have some coverage there to provide some income. Another form would be an annuity. You could purchase an annuity if you have a big asset that you want to cash in and turn into a stream of income. That is an option that some people will take advantage of, and that's usually something that you can purchase through an insurance company as well, or a financial advisor. Now, back to John's point. He is absolutely correct. There are times that you want to be very, very careful about what you leave and to who. And I have had clients in the past who said, I don't want to leave anything to my children. I want it all to skip the generation and go to my grandchildren because my children are a mess right now. They're just a hot mess. And so I want to make sure that my grandkids are provided for and that my kids can't screw that up. And so in those circumstances, trusts can be a very useful tool. I would say that anytime you have an attorney tell you, oh, everybody should have a trust, you want to be very careful about that. I have heard some folks come in and say, well, I heard that one time. This attorney told me everybody needed a trust. That's not necessarily true. Trusts do tend to cost more money, but it's because they provide a whole lot more flexibility. There are sometimes ways, if you have someone who's got really limited means, there are sometimes ways that we can backdoor this and use some of these other tools to accomplish the same things. And so not everybody needs a trust, but we're going to talk about some specific things that trusts do and ways that they can kind of help address some of these issues so that you can see how beneficial they are from time to time. The first thing that you need to know about trusts is that they can be revocable or irrevocable. And that just means if they're revocable, I keep the power to either shut this entire thing down, or I keep the power to change it. I can change the beneficiaries. I can change what goes in or out of the trust. I have the power to make changes to that. If it's irrevocable, then I don't retain that power. It's very difficult to change the trust and the terms of the trust after that. There are reasons why you would want to do an irrevocable trust if you're looking at things like Medicaid planning, but most trusts are revocable because people want the flexibility to be able to change the terms of those trusts. There are things for tax planning trusts. So most of the time we don't have to worry too much about this, especially with our estate tax threshold as high as it is right now. But if you have a ton of assets, if you're super wealthy, there are trusts that are around and created that you can kind of shelter your assets for tax purposes. I would venture to say probably none of us on this call are going to need to worry about that. So we'll skip on. Now, this one is something that can be very useful. A special needs trust is it's a type of trust that you can set up when you have someone who has a disability, and you want to be able to leave them an asset or a cash resource or some sort of inheritance without messing up their public assistance benefits. The purpose of these trusts is that it's designed to supplement the public assistance, not supplant it. That's the technical terminology that they use when they're looking at these. In other words, we're not trying to defraud anybody. We're just simply trying to put aside a pool of money or asset so that we can pay for things that this public assistance doesn't. And so a lot of times these special needs trusts get funded and they get used for things that Medicaid doesn't pay for. If there is a certain type of medical procedure that Medicaid doesn't want to pay for, this fund can pay for that. It can also pay for, things like, recreation. If you want to pay for a vacation for your disabled relative, you can use those funds for that. Now, you can't take the whole family. You can't pay for the whole, 32 people to go, but you can pay for your disabled person out of that fund. So the tax laws give us special things that we can pay for out of this, and it allows you to provide financially for your person with special needs without cutting them off from their benefits. So this is one that is especially useful if you have a child or an adult even with special needs. Trusts give us probably the highest level of flexibility. We see trusts used a lot in blended family situations because we want to make sure that we don't cut off our spouse and leave our spouse destitute, but we also want to make sure that the bulk of our estate passes on to our kids. And as we saw from Charlie and Cindy, that's not always how it works out if we are left to our own devices. And so in those blended family situations, trusts can be really, really useful because they give us so much flexibility. The other benefit to trusts is that they do not go through probate as a rule. So in other words, if you draft a trust by an attorney, have an attorney do that for you, then when it's time for that trust to be administered, it just happens. They just do it. It doesn't have to be signed off on by the court, doesn't have to have any approval. Now, if there's a dispute, it can go through the court, and there are some laws that govern the trusts and how they're administered, but typically speaking, trusts do not go through probate court. All right, so those are some of the really common tools in our toolbox. Now I want to back up and apply this to Charlie and Cindy, and let's see how these things could have helped them. Because now that we've learned about these tools, I'm sure your head's already spinning about ways that, hey, I think I could have plugged that in there and it might have helped. So we're going to look at what they could have done differently. First of all, we've talked about this a little bit. They could have established a trust. One of the things that they would have wanted to do as a result of that would be providing financially for their individual children. Like I said, we want to make sure that that spouse doesn't have to starve to death just because one spouse dies, but we also want to make sure that my kids' share goes to them. I don't want them cut out. And remember that Cindy has Chandler with that cerebral palsy issue. And so he may very well be able to benefit from a special needs trust. She may be able to have set aside maybe her $100,000 certificate of deposit, for example. She may have been able to fund that special needs trust with that asset, and then Chandler would then have some extra money to be able to supplement what Medicaid might not have paid for. The other thing that a trust would have done for them is it would have caused an avoidance of probate court. So after they both passed, we had to go back to the probate court and figure out who did what with their stuff. A trust would have eliminated that for them. Now, they could have also used last wills and testaments. That would have allowed them the flexibility to address the legal guardianship issues for Chester, who, remember, is 15. He's a minor. And so that would have allowed Charlie to have named a legal guardian for him, to have designated someone that he felt was appropriate under the circumstances. And so, the benefit to this is you can even name a backup. So, maybe he would have chosen Cindy. Maybe he would have said, hey, if I can't take care of Chester, I want Cindy to do it. Well, Cindy's already out of the picture because she's got her own incapacity. He could have named a backup. And so it gives us a lot of flexibility there. He could have used that as a tool to address that guardianship issue. The other benefit that would have helped them is a last will and testament would pour over any missed assets to the trust. So if they had set up a trust, you have to title those assets in the name of the trust. So they would have had to have transferred their house to the Charlie and Cindy Living Trust, their vehicles to the Charlie and Cindy Living Trust. And if they missed anything, it wouldn't automatically go to the trust. But this last will and testament could have said, hey, if there's any asset that I die leaving just in my name, I want it to go into the trust and be distributed according to the terms of my trust. So again, it really would have simplified the process for them to have a last will and testament. The real key here, I think, is that each of them needed to have a power of attorney. Remember that Cindy was the very first one that we had to go to court for to get that guardian and conservator appointed. If she had had a power of attorney, the court wouldn't have had to have gotten involved at all. If she had done a power of attorney and named Charlie as her agent for that, the moment she became incapacitated, his power would have kicked in. He would have been able to make those decisions. He would have been able to deal with the hospital and with the medical providers and with the nursing home. None of that would have had to have gone through court. And so that power of attorney document, I think, is especially important for each of them under the circumstances. Life insurance, that would have been a big tool, a big help for them under the circumstances, right? Because remember, they had a lot of debt. They had their mortgage. They had debt on both of their vehicles. They had $55,000 of credit card debt. And all of that stuff doesn't just go away. And so if they had had life insurance that was sufficient to pay off that debt, that really would have helped the family. It also would have provided some financial assistance for whoever ended up raising those kids and maintaining those households. You all know better than anybody how expensive it is to feed and clothe kids, right? And so, just because you've named a guardian, that may not be enough to consider. You may also need to figure out, how am I going to help that guardian be able to afford this? If I want my kids to continue to be raised in their family home, how am I going to help that guardian afford to keep that family home? And so life insurance, again, could have been very useful for them under those circumstances. They could have utilized the non-probate transfers. Remember that we talked about, they had those gun and coin collections that they wanted to pass to their respective heirs. But for poor Charlie, his gun collection got split between Cindy and his son because of the way that the probate worked. They had to go through probate court. The law was what it was, and Cindy got one half of the gun collection. And so if he had utilized that non-probate transfer of just gifting the gun collection to his son to start with, he wouldn't have had that problem. And again, it just makes sure that those assets are passed to whoever you intend for them to go to. And so you can see, failing to plan, not making any plans, is a really, really bad idea. It's not just bad for you, because it results in a lot of heartache and a lot of complication for you. It's also bad for the children that are in your home, or the children that you have who have special needs. It leaves them very unprepared. It leaves them in a very precarious position. And not only that, it's a whole lot less expensive to plan in advance than it is to have to do damage control after the fact. Because you know what? In Charlie and Cindy's case, we've been to court 6 or 7 times now. Do you know who's making the money? The lawyer is making the money. They are profiting off of this family's train wreck of a life, and that's not right. That's not how you want to leave the situation. So it is absolutely vital to plan and to take those tools that are in our toolbox and use those to help improve our situation.